Let us begin the course on economics of IPR. The first lecture is on intellectual property rights, introduction and historical overview. So, the brief outline of this course is to introduce the intellectual property rights, different conventions of intellectual property rights in last few decades, intellectual property rights in the multilateral framework, and the concluding observation. So, let us begin the basic concept of intellectual property rights. Intellectual property is the creation of the human mind. The legal rights that protects these creation of minds are known as the intellectual property. So, IPR provides its owners the time-bound right to prevent others from using their intellectual property based on predefined and legalized criteria. So, why the entire discussion of intellectual property right is time centric. For some of the intellectual property rights, time is a very important factor in the entire decision. So, there are two main areas of intellectual property rights in past. IPR are normally separated into two main areas. The first one is the copyright and rights related to copyright, and the second one is the industrial property. So, copyrights are the rights to the authors, to the creators, to the singer, to the musician, and certain other related activities of the writing, singing, and music are also known as the related rights to the copyright, which is also named as the neighboring rights in intellectual property framework today. And then the second type of intellectual property is the industrial property, such as the patent, industrial designs and circuits. So, there is a complete demarcation between the copyright and the rights related to copyrights and the industrial property. So, industrial property is completely linked today with the research and development activities, lab activities, and out of those research and lab activities, the new innovations and inventions and the new technology which is coming out is again the matter of protection, and which comes under the protection under the industrial property. But the writer's right and the singer's right and the art and culture products, these are all the part of the copyright material. So, there are various conventions for the protection of intellectual property rights. One of the oldest and very important convention of the protection of intellectual property right is the Paris Convention, and this applies to the industrial property in the broader sense. That includes patents, trademarks, industrial design, utility models, service marks, trade names, geographical indications, and the control of unfair competition. So, this international agreement was aimed at ensuring the protection of intellectual works in various countries, and was the first major steps to help the creators. So, this is the beginning of the major steps to protect the intellectual property right, especially in the industrial property sector. The new after this, another convention was in 1886. It was adopted to protect the works and rights of their authors, mainly related to the copyright, and this convention deals with providing the authority and the terms and the conditions to control the artistic and other similar works of authors, poets, musicians, etc. And it has the provision to grant the minimum protection. So, it also provides special provisions that are mandated for the developing countries. For more detail, we are giving you the link. You can just find out the major discussions on these issues through this link, and that will be always beneficial for you to get more idea. So, the Rome Convention is another convention which again one of the important convention in terms of which protects the performers, producers of phonograms and broadcasting organizations. WIPO, World Intellectual Property Organization, is mandated for the enforcement of the Rome Convention together with the International Labour Organization and the UNESCO. Again, for more details, you can again find out this link on the Rome Convention. So, there were many other conventions which is equally important in the field of protection of intellectual property rights. Brussels Convention 1974, Washington Treaty, Trademark Law Treaty in 1994, WIPO Copyright Treaty 1996, Patent Law Treaty 2000, and Singapore Treaty on the Law of Trademarks are the major one which has tried to protect the different types of intellectual property rights in past. IPR in the multilateral framework. Today when we see the intellectual property right is no longer the matter of the bilateral discussion and decisions and bilateral agreement. After the General Agreement on Tariff and Trade, especially the last round of General Agreement on Tariff and Trade, which is known as the Uruguay round, we find that Uruguay round was the first round which has introduced the trade related aspect of intellectual property right in detail, and this was one of the major attempts by the world community to enforce the intellectual property rights at a global level, and that was a very aggressive controlling system adopted by the General Agreement on Tariff and Trade. And before that, we find that various types of intellectual property rights protection and related discussions were available in various rounds of GATT. And we have also seen that different conventions also try to evolve a global system of protecting different types of intellectual properties in past. But this is the first step where the country adopted a very, especially the GATT General Agreement on Tariff and Trade, adopted a worldwide negotiation on trade related aspect of intellectual property right, and this is one of the long period negotiation in the world which continued from 1986 to 1994 before the establishment of World Trade Organization. And why it is different? Because this particular agreement, trade related intellectual property rights agreement, is one of the agreements which has given the major challenge for many developing and least developed countries, and countries were not really aware that we have to adopt a system which is going to have a very much globally controlled mechanism, and they never thought that they have to have a system within the country. Domestic law should be equally important and equally placed to protect the interest of the global treaties such as TRIPS. So, after a huge negotiation and discussion of this particular trade related aspect of intellectual property rights, world had adopted the TRIPS agreement through WTO in 1995, and this is the major you can say major umbrella where various countries are now adopting and evolving their domestic law to comply this particular TRIPS agreement. So, we are today in the multilateral framework of TRIPS agreement. So, this agreement, different members are really having the package deal obligation today. What is basically in the package? A country cannot really have a different type of rules and regulations at their domestic economy. In fact, country must have the complementary rules and order to comply the existing rules, existing agreement. So, this means that the membership of the World Trade Organization is subject to all the agreements, and members cannot have the opinion to choose from the agreements, but it is in toto that a member has to comply those agreements, and but at the same time country can have a different opinion on certain articles, and country can really go and bargain at the World Trade Organization for certain aspect. So, such liberties are there, but those liberties are based on the agreement, those liberties are based on the discussions and deliberations, and it is not the single country's motive or single country's decision that whatever they feel like they can adopt and whatever they understand, they are going to continue with those principles and those laws. It is not going to continue. So this obligation makes this particular trade related intellectual property rights agreement quite distinctive from the other deals in past, especially on the intellectual property, because they are subject to all the WTO ministerial agreements and multilateral agreements, and different ministerial conference has in WTO has also complemented to have this agreement continuing in the world today. So the important measures of trade related intellectual property rights are two basic international trade principles to member states regarding intellectual property. So there are two basic principles. One is the national treatment and the second one is the most favored nation treatment. So let me also discuss in brief that what is basically the meaning of national treatment and how this national treatment should be maintained, and what is basically the MFN treatment. So national treatment means the way you treat your intellectual property forms within your country, the similar treatment you have to provide to the other firms or other creators, other innovators coming from outside the world. So the national treatment provides the country a clear cut guidelines that you cannot discriminate a country on the ground that the treatment which you are providing to your economy will be different from the treatment which you are providing to other firms coming from other part of the world. So, and the second point is the most favored nation treatment. So suppose if you have provided certain tariff reduction or certain flexibility to a country, that flexibility will be automatically given to other countries involved in the trade with you. All these firms are on the equal platform. So the basic objective and motive of national treatment and most favored nation treatment is to provide a very clear cut and very transparent framework of intellectual property rights, where countries and the firms are not being discriminated on the ground of nation and outside the nation principle, but all these firms are on the equal platform. All these firms are equally treated any country in the world. So this is the basic principle of WTO on which most of the agreements are established today. But we find that country to country these national treatment and most favored nation treatments are being violated, and large number of cases are basically in the dispute settlement body. WTO has a dispute settlement body where a country can file a case against another country and naming that and explaining that what has been major problem in the country in terms of the protection of most favored nation and the national treatment status. So the TRIPS agreement establishes minimum standard for the availability and the scope and the use of 7 forms of intellectual property. Before that, we have found that different conventions has tried to find out protection and deliberations on a particular intellectual property rights. So Paris Convention more towards the industrial properties, while the Bern Conference and Rome Conference they were trying to have a more copyright related agreements. So and the trademark and other aspect also came in other conventions. So we are finding that different conventions has tried to find out and to evolve a intellectual property rights system where a global network and global platform should be evolved to protect the interest of the owner. But TRIPS is the single umbrella where all these 7 7 major intellectual property rights are combined together, and the rules were framed and the agreements were signed by the members of the world community. And because of this, today we are having a global framework of intellectual property rights, and the rules set by this TRIPS agreement is the rules adopted by every country in the world. There are some specific examples where some of the countries are not really able to cope up with these agreements. So some of the countries are given some time to evolve certain rules and obligations according to the TRIPS agreement, and many least developed countries are also trying to evolve such rules and obligations. But the fact is that one cannot say today, a country cannot say today that we are going to really reject the TRIPS agreement. It is not possible today, because every country has shown its interest, and every country has really established some of the local laws to protect the trade related intellectual property rights, and this shows the minimum standard of capability and the scope and the usage and the protection of 7 forms of intellectual property rights in the multilateral framework, which is again evolved at the local level also. So, what is basically the main objective of this TRIPS agreement? The Article 7 of this TRIPS agreement, the general guidelines, shows that the intellectual property rights protection and administrations aims at stimulating the technological innovation. The basic aims and basic objective is to innovate, to stimulate the technological innovation in the country, and to administer these intellectual property at a very large level. So, technological transmission and diffusion, which was very slow before the establishment of TRIPS agreement, today we find that many countries, many smaller countries are also very much important player in the protection of intellectual property right, and they are really coming out with various technological products today, and industrial products are coming out, electronic products are coming out, and the technological transmission and diffusion is more faster scale today compared to past. So, this shows that the objective of trade related intellectual property rights is being fulfilled today, because if you see the United States as an example, 70% of United States GDP is because of the contribution of the intellectual property rights product. So, this shows that how IP products and IP based products are one of the major contributor of the GDP, especially in developed country, and some other examples from Korea, Singapore, Hong Kong, Taiwan is also showing us that technological transmission and diffusion is on faster scale. At the same time, technological knowledge should be mutually beneficial for the producers and users. So, today we find that technological products and technological knowledge is no longer the matter of monopoly. The country today is very much engaged in evolving and producing technological products, and there is a huge competition among the countries to find out that which country is going to have a best product in the world. So, we are not really living today in the world where only few countries were really having the technological transmission and technological product produced. But today we live in a world where the technology produced in one country is no longer the monopoly of the technologically produced product in that particular country, but it is transmitting so fast in other country. So, one cannot say that a technology produced in a country is going to continue forever, but maybe a neighboring country or maybe a smaller country can challenge that technology within few months, and that way we are in a very fast moving technologically driven world compared to past, and credit goes to the intellectual property rights system evolved after the TRIPS agreement. So, we cannot deny really that these intellectual property rights are also having the economic, social welfare. So it has really enhanced the social connectivity. We find today that lots of IT products are really connecting the world. We cannot really deny this fact that compared to last 50 years, 40 years, we are more connected and more interlinked today. So the credit goes to the new types of innovations and technological products which is under the protection of intellectual property rights, because intellectual property rights gives you some incentives. If we have the ownership of intellectual property rights, we are certainly having certain incentives, and that incentives is time bound. If a person is having patent, a patent can be can give you the economic return for many years, more than 2 decades, and that way you are having the economic age when you are really protecting a certain intellectual property. So through this we are really competing to each other. Firms are competing to each other due to grabbing the incentives, economic incentives involved. But if you connect this with the Adam Smith's invisible hand theory, it is not only the economic benefit of that particular person, but there is a benefit trickling down to the society. World as a whole is more connected today. World are more satisfied in terms of getting new products compared to the world where people have to wait for even for the basic telephone connections for a many years. So, but the point is, the ultimate goal of this entire TRIPS agreement is to have the rights and obligations in a very balanced way. So, if you have the rights of protecting the intellectual property, you have also the obligation to protect the intellectual property of others. So, world cannot and the country cannot say that we have to have we should have the right to protect our own product, but we don't bother to protect the intellectual property of others. That is not going to work. So the ultimate objective of TRIPS agreement is to balance, to evolve a very balanced IP world where rights and obligations are complementary. The obligations and rights both are matching to each other, and social and economic welfare is not only individualized, but it is going to have more and more mass impact. At the same time, technological knowledge should be mutually benefit for the producers and users. It is not only the producer's cake, it should be also the user's cake. So the production of intellectual property products and the technological products, today we find that the firms are more greedy in nature, and they want to exploit the market, but the fact is that more they are trying to exploit the market. Some of other global forces are equally active to protect their creation and innovations and their technological products in the world, and they are also coming out with a new product. And so the world is not really monopolized world today. It looks like the intellectual property or the patent monopolizes the world, but when we see the electronic items, when we see the other IT products, we find out it is not really the world of monopoly, because we are really having large number of competitions through the technological transmissions and diffusion. But at the same time, we also find that there are certain challenges, issues on the way. Firms are not really having to capture the entire firms are not really having motive to distribute their economic benefits. They want to grab the benefits of the intellectual property, but slowly some of the firms, and if the rules are clear and tight, then firms are not going to become really the monopolist firm. If global forces are active, if different eyes are active to catch those free riders, if different eyes are really dynamic to find out the ways to protect the interest of the smaller and small firms and small countries, we don't find that world is going to become a monopolized world. So there are significance of this TRIPS agreement, because this is the most leading agreement, exclusive multilateral agreement with generating the minimum protection requirement of 7 forms of intellectual property. It is the foremost global intellectual property agreements that has the provisions for comprehensive enforcements requirement, including civil and criminal provisions. It has the irrevocable and enforceable dispute settlement mechanism, which is crucial for sustaining and contemporary global intellectual property framework. So, the broader issues of TRIPS is to apply the fundamental principles of the trading agreement and other international agreement of intellectual property, which is not really in place. There are certain drawbacks on the way. At the same time, adequate protection of intellectual property rights are not in favor of many countries today. Enforcement of intellectual property rights effectively in other countries, and dispute settlement of intellectual property between the WTO members is another challenge, because sometimes it takes time to find out the solution. And the transitional provisions when the new system is being introduced is another issue of the TRIPS agreement. There are limitations of the TRIPS agreement, because the TRIPS agreement is 2 decades old. It does not address several new developments. The internet and digital copyright issues is another challenge. Advanced biotechnology, international harmonization is another limitation of the old TRIPS agreement. The process of creating uniform global standards of law or practice is another limitation, and it determines the floor and not the ceiling of minimum intellectual property right protection. So, with these challenges, the recent one of the recent Doha round, which is more in controversy today, which also had some of the intellectual property rights as a part of their agenda. Doha round negotiations included this single IP issue. It aims at protecting wines and spirit in participating countries, especially in the geographical indications sector. The tasks were started in 1997 and were included in the Doha round in 2001. Other intellectual property issues, such as few members of the WTO liked consultation on 2 other issues, and to associate these to the register for wines and spirit. GI extension is still biopiracy. Benefit sharing and traditional knowledge is another issue which was evolved in Doha round. In order to implement the agreement on TRIPS on patents and undisclosed information requirement, the extra 10 years were granted to the least developed countries, because they are related to the pharmaceuticals. So, with this overview from history to present, we find that there is a need for more wider intellectual property rights protection today. Besides 3 conventions on different aspects of intellectual property right, there remained a lack of proper and adequate legal and binding framework for the protection of intellectual property in the world today. TRIPS was mandated to fill that gap, but with different lectures and different discussions of this course, you will find that even after having the national treatment and most favored nation treatment, world is still unequal in terms of intellectual property rights protection, and we'll try to explore many more challenges and issues through different lectures in this course. Thank you.